Friends, welcome to Shorthand Regnant and ready for dictation. Start. The second appeal arises in proceedings in execution of the decree of the District Munsif's Court of Kannur for money in original suit number 591 of 1896. Stop. The present application for execution was presented on 27th September 1909. Stop. The decree was passed on the 15th January 1897. Stop. So this application was put in more than 12 years after the data of the decree. Stop. The judgment debtor objected that the application was barred by section 48 of the Code of Civil Procedure as more than 12 years had elapsed since the date of the decree and the decree holder had made prior application for execution. Stop. The application immediately preceding the present one was preserved on the 11th January 1909 for attachment of defendants' movables and for their arrest. Stop. While that application was still pending, the present one was pub in addition to the reliefs asked for in the previous application, the plaintiff prayed also for the attachment of immovable properties belonging to the defendants. Stop. The district munsif disallowed the objection, holding that the defendants were fraudulently evading the execution of the decree and that therefore the bar under section 48 civil procedure code did not apply. Stop. On appeal, the district judge confirmed the munsif's finding of fraud so far as the first defendant was concerned. Stop. As he had evaded the execution of warrants of arrest taken out against him in order to defeat the execution. Stop. But it hold that no fraud was proved against the second defendant. Stop. He was, however, of opinion that as fraud had been proved against the first defendant, the plaintiff was entitled to execute the decree against both the defendants. Stop. The second defendant has appealed to this court against the order of the district judge. Stop. His contentions are that the finding of fraud as against the first defendant is not based on legal evidence. Stop. That even if that finding be upheld, it has not been proved in the case that the plaintiff exercised due diligence in the execution of his first defendant's fraud from realizing the amount due to him, and that this court has a discretion to refuse execution in the circumstances, and that in any event the first defendant's fraud would not justify the granting of the execution against the second defendant. Stop. With regard to the first contention, I am of the opinion that it is not entitled to prevail. Ms. Rosario arguments on this point is that the district judge acted illegally in relying on the statements contained in the preserver's returns as evidence of international evasion of the warrants of arrest by the first defendant. Stop. But in my opinion, the returns are admissible under section 35 of the Evidence Act as evidence of the facts reported by the process servers. Stop. Even if the statement of the process server that the first defendant left his usual place of residence in order to escape arrest should be regarded as illegally inadmissible, it was open to the district judge infer from the circumstances of the case that his absence was due to a deliberate attempt to evade arrest. Stop. It has been fully established by decided case that the expression fraud in section 8 should be construed in a broad sense, and that a deliberate evasion of the process of the court with intention to defeat the execution of the decree would amount to fraud. Stop. I would overrule this contention. Stop. I am also of the opinion that the second contention is equally unsustainable. Stop. Section 48 Civil Procedure Code provides nothing in this section shall be deemed to preclude the court from ordering the execution of a decree upon an application presented after the expiration of the said term of 12 years, where the judgment debtor has by fraud or force prevented the execution of the decree at some time within 12 years immediately before the date of the application. Stop. Fraud at some time within 12 years prior to the application for execution being sufficient to entitle the decree holder to ask for execution, it is clear that it is not incumbent on him to show continuous diligence during all the time prior to the application. Stop. The language of this section also shows clearly that the decree holder is not bound to show that, but for the fraud or force complained of, he would have realized to fruits of his decree. Stop. All that has to be proved is that the judgment debtor by fraud or force at some time prevented the execution. That is, in my opinion, made the decree holder attempts to execute at the time to which the fraud relates unsuccessful. Stop.